Mr. President, so that all are clear with respect to where matters are with the cybersecurity legislation, a couple of days ago, it was my fear, Mr. President, that this bill would be brought up. It's a badly flawed bill, and it would be brought up with no opportunity for senators on both sides of the aisle to fix the legislation. It'd come up with no amendments. People would say, oh my goodness, there are serious cyber threats. That is unquestionably correct. My constituents, for example, have been hacked in Oregon by the Chinese. And people would say, we've got all these cyber threats, we've got to act. And there would be no real opportunity to show how the legislation in its current form creates more problems than it solves. Now, so that all concerned understand where things are, there are going to be more than 20 amendments to this badly flawed bill. Those of us who want to make sure that there's a full airing of the issues have come to understand that there is no time limit that has yet been agreed to on those amendments. So there's going to be a real debate. And of course, that's what the United States Senate is all about. And I particularly want to commend the millions and millions of advocates around the country who spoke out. I understand there were something like 6 million faxes that were sent to members of this body. And I'm just going to take a few minutes, I see my colleagues are here as well, to describe where I think this debate is and give a sense of what the challenge is going forward. I start with the basic proposition, Mr. President, that we have a very serious set of cybersecurity threats, as I touched on, seeing it at home. Second, information sharing can be valuable. There's certainly a lot of it now. It can be constructive. Information sharing, however, without vigorous, robust privacy safeguards will not be considered by millions of Americans to be a cybersecurity bill. Millions of Americans will say that legislation is a surveillance bill. So what I'm going to do tonight, just for a few minutes, because of my understanding there are colleagues who'd also like to speak, is describe exactly where this debate is. As written, the cybersecurity legislation prevents law-abiding Americans from suing private companies that inappropriately share their personal information with the government. When I say personal information, I'm talking about the contents of emails, financial information, basically any data at all that is stored electronically. CISA, as the bill is called, would allow private companies to share large volumes of their customers' personal information with the government after only a cursory review. And colleagues who want to look at that provision ought to take a look at page 16 of the bill. And we were told repeatedly that this legislation was voluntary. Well, the fact is, it is voluntary for the companies. But for the citizens of Pennsylvania, the citizens of Oregon, those across this country, it's not voluntary. The people of Pennsylvania won't be asked first whether they want their information sent to the government. Oregonians won't have the chance to say whether or not they want that information sent. For them, this legislation is mandatory. Now, to explain the damage that I believe this legislation would do, I want to take a minute to explain how cybersecurity information sharing works now. Right now, the Department of Homeland Security operates a national cybersecurity watch center 24 hours a day, 7 days a week. This watch center receives cybersecurity threat information from around the federal government and from private companies. And this watch center sends out alerts and bulletins to security professionals to provide them with technical information about cybersecurity threats. In fiscal year 2014, this watch center sent out nearly 12,000 of these alerts to more than 100,000 recipients. That happens today. Lots of companies participating. The system that's in place today includes rules to protect the privacy of law-abiding Americans. These rules ensure that companies have a strong interest in protecting the privacy of their customers. But the legislation, as it's been written now, overrides those rules. The bill in front of us prevents individual Americans from suing companies who have mishandled their private information. As a result, companies would suddenly, in my view, not have the same incentives with respect to care about sharing their customers' personal information with the government. And my concern, and the concern I believe of millions of Americans, is that the interests of some who are overzealous in government, overzealous in the private sector, would overwhelm the interests of all those customers who've handed over their information voluntarily. And I thought I'd just give a couple of examples of the problems that the bill in its current form causes. Imagine that a health insurance company finds out that millions of its customers' records have been stolen. If that company has any evidence about who the hackers were or how they stole this information, of course it makes sense to share that information with the government. But that company shouldn't simply say, here you go, and hand millions of its customers' financial and medical information over to a wide array of government agencies. The records of the victims of a hack should not be treated the same way that information about the hacker is treated. If companies are sharing information for cybersecurity purposes, they ought to be required to make a reasonable effort to remove personal information that isn't needed for cybersecurity before that information is handed over to the government. And those government agencies ought to focus on using that information to combat a cybersecurity threat. That, Mr. President and colleagues, is not what the bill says. Page 16 of the bill would very clearly authorize companies to share large amounts of personal information that's unnecessary for cybersecurity after only a cursory review. Now, I want to talk about just one other issue specifically that I think senators are not familiar with, and that is the issue of cyber signatures. Cyber signatures are essentially recognizable patterns in online code. A number of informed observers have raised the concern that once individual cyber signatures are shoveled over to the government by private companies, they could be used as the basis for broad surveillance affecting law-abiding Americans. Now, I'm not going to confirm or deny any of the press reports that have raised concerns about cyber signatures being used in this way. But I believe senators should understand that this is certainly, and it's been being widely discussed in the public arena, a theoretical possibility. And that helps underscore the importance of including a strong requirement for private companies to remove unrelated personal information about their customers before dumping data over to the government. I also, in wrapping up, would be remiss if I didn't note that a secret Justice Department legal opinion that's clearly relevant to the cybersecurity debate continues to be withheld from the public. This opinion interprets common commercial service agreements, and in my judgment, it is inconsistent with the public's understanding of the law. So once again, Mr. President, we have this question of what happens when the people of Pennsylvania, Virginia, or Oregon think that there's a law because they've read it in the public arena or on their iPad at home, and then there is a secret interpretation. I've urged the Justice Department to withdraw this secret Department of Justice opinion that relates directly to the cybersecurity debate. They've declined to do it. I suspect many senators haven't had the chance to review it, and I would urge, as I have done before on this type of topics, I would urge senators or their staffs to take the time to read it, because I believe that understanding the executive branch's interpretation of these agreements is an important part of understanding the relevant legal landscape on cybersecurity. And I'm going to close by talking about the question of effectiveness, because I think we all understand that we are facing very real cyber threats. I'm of the view this bill, in its present form, would do little of anything to stop large, sophisticated cyber attacks like the Office of Personnel Management hack. And I don't think senators ought to take just my word for it here. In April, 65 technologists and cybersecurity professionals expressed their opposition to the bill in a letter to Chairman Burr and Vice Chairman Feinstein. In referring to the bill and two similar bills, they wrote, and I quote, "We appreciate your interest in making our networks more secure, but the legislation proposed does not materially further that goal, and at the same time it puts our users' privacy at risk." As they wrap up their letter, this group of technologists and cybersecurity professionals state, "These bills weaken privacy law without promoting security." And Mr. President, that has always been my concern. If you look back at our experiences as we try to write these new digital ground rules, and fortunately we took a step in the right direction as related to NSA rules, the challenge has always been the same. The people of our country want to be safe and secure in their homes and in their businesses and in their communities. And they want their liberty. And Ben Franklin said anybody who gives up their liberty to have security doesn't deserve either. What troubles me, and why I am glad that the Senate has stepped back from precipitous action where we would have just passed this bill without any amendments, we'll have a chance in the fall to look at ways to address cybersecurity in a fashion that I think does respond to what our people want, and that is to show that security, in this case cybersecurity, and liberty are not mutually exclusive, that sensible policies worked out in a bipartisan way will respond to the needs of this country in what is unquestionably a dangerous time. With that, Mr. President, I yield the floor.